Hello, good evening. This is U.S. Immigration Attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions. Go ahead and put your questions in the comments so that I may answer those questions. Now, I have a great topic for you today. I'm going to be talking about what if you get a request for evidence or a notice of intent to deny? What if you get those in the mail? What does it mean, and what do you need to do to make sure that you save your case from denial? Now, if you get these, it's very important for you to understand that you are on a tight deadline to respond to it in order to avoid denials. So, a request for evidence is usually after they have done a review of your application and they've determined that they have additional questions, or maybe you have not yet submitted any of the or one or more of the requirements in order for them to make a final decision or to schedule that interview if you do have an interview in whatever application you're filing. And in this case, it's important to review it very carefully, and at this point get legal advice and representation to figure out how you should approach it. The complexity of a request for evidence is going to vary depending on the type of petition it is. If it's based on an employment type situation, they may have questions for the employer. They may have questions about the qualifications of the applicant who is applying for maybe a specific employment-based visa or green card. If it's a family-based, they may have questions about the relationship. For example, if you're doing a parent-child and you submit the birth certificate without the father's name on it, they may follow up with questions about paternity and how you can prove that the parent is really the parent that should be the biological, adopted, or step parent. So it's proving the relationship. And then it may involve legal issues. It may involve issues of whether you qualify in the first place. So it's really going to depend on what type of petition has been submitted or application has been submitted and what they found, what is the further information they'll need. Same with the notice of intent to deny. Now, a lot of people get that notice of intent to deny and they automatically think this is a denial. It is not a denial yet, but what they're doing is they're giving you a heads up to tell you they plan to deny it unless you can change their mind. If you can provide them information or evidence that will change their mind, or basically counter what they said is the basis for the denial, then they may turn around and go ahead and grant the approval. And of course, that's going to vary too. It's going to vary from case type to case type. And that's where it's going to, and no RFE, no notice of intent to deny is going to be the same. They're all going to present different questions just based on your particular circumstances. This is time sensitive. So usually with the RFE, they'll give you around 60 days, and they will put the deadline date on the request for evidence. With the notice of intent to deny, you usually have 30 days to respond. But here's the good news. The good news is right now, right up until October, so March, with any RFEs, any notice of intent to deny, even the ability to appeal, because appeals do have a deadline, you do have 60 days, additional days on top of the deadline to go ahead and apply. And this is going to go up until October. So right now, where it was extremely time limited, you still have time to go and seek legal advice, seek legal representation, and submit a proper explanation or evidence that they may be requesting. It's important to address each issue in the notice of intent to deny or the request for evidence. The reason is if you miss an issue that they say they're going to deny you on or that they need, then once you respond, and if you don't address that one issue, they could deny it on that basis. So a thorough response is required. So I assist with these. Go ahead, call, schedule a consultation, and then we can go through the request for evidence or the notice of intent to deny. But here's a tip from me. The way that you can also reduce the chances of getting a request for evidence or to be prepared for any kind of request for evidence or notice of intent that's going to come in is by seeking legal advice before you file anything, and also get that representation to make sure that all the requirements are met, all the requirements are submitted. So that's going to be very important before, and you avoid the anxiety, you avoid the stress, and you avoid the rush of trying to respond. In addition to that, I, as the attorney, when I come late into a case like that with a request for evidence, I do have to spend time to get to know the case, to understand the issues before responding. And if there is a limited time to respond, it does make it harder and more expensive to respond to these. So before you even apply for anything, make sure you get the legal advice and representation you need. Now, I'm also here to answer questions. So go ahead and put your questions in the comments, and I will answer your questions as they come in. Thanks for the follows. Thanks for the love. I really appreciate it. You can go ahead and put any immigration related questions in the comments, and I already see one on YouTube. So how long does the process for removal of conditions take? The immigration give notice for interview last January 26, 2022 for my removal of condition. Until now, I don't have yet received a notice. So, sometimes you get a decision right after the interview. Sometimes it just depends on what's going on in your case. You really should make sure you get legal advice, representation, because to wait, if it's January and it's now August, you want to make sure you're keeping up on your case, that you haven't received any further correspondence. And also, there may be a need to submit an inquiry into why it's taking so long. So it's hard, I'm not the attorney, I'm not your attorney. And so it's hard to tell you why. There could be a number of reasons why there is a hold up here. Usually with the removal of conditions, when it is going well, we get a decision right away or right on the spot. So yes, if you attended your interview and you still haven't gotten any kind of answer, it's going to depend on what came up in the interview, what came up in the interview, what are the issues involved. Were you separated? Is this a waiver? Did you submit sufficient evidence to address the bona fides of the marriage? Did your spouse attend with you jointly? So many questions that I would have to answer before I could even comprehend what went on in your case. All right, keep putting those questions in the comments. I'm here to answer your questions. So put those questions in the comments. It can be anything that's immigration related. I just talked about what you should be doing if you get a request for evidence or a notice of intent to deny. Now, neither means that you are going to be denied, but at this point, if you don't respond to the request for evidence or the notice of intent to deny, or you don't timely respond or properly respond, then you will get denied. So it's very important that you make sure that you get help to move forward in your process. So if you can all see me now and it's no longer stuck, just let me know, because I see Giz James, I see now you've put your question. I was asking if my son can file for me after getting a green card. So green card holders can't apply for their parents. They can apply for their parents once they've become a citizen. So your son would have to wait until they're a citizen. Okay, so what I mean is until now, I don't receive a notice for my interview for a schedule. So if they're saying it's ready to be scheduled and it hasn't been scheduled, that is also normal. But if they said that they sent an interview notice and you haven't received it, you definitely need to follow up with that with the USCIS. But I know it's frustrating. Sometimes they say it's ready to be scheduled for an interview and then nothing else happened. So just keep up on your case, and you're not alone if that's the case. So I think they have to wait 5 years to get citizenship. It depends. So if your son is married to a US citizen and he got his green card that way, and he continues to be married to the citizen for 3 years and keeps his green card for 3 years, he would be able to get it within 3 years. However, if he got it any other way, through a parent, through a job, through humanitarian means, then it's going to be 5 years. So if he married a citizen and as you know, if he stays with his citizen, he's married to the citizen for 3 years, he has his permanent residence for 3 years, then he could apply in 3 years. So exactly 2 years and 9 months. So I just checked the status of my case and it says it's been actively reviewed. Then when will they decide? We don't know. That is a norm. That is not, you're not going to get a decision tomorrow. When they say that it is actively being reviewed, it just means it's probably sitting on somebody's desk somewhere, maybe even at the bottom of that pile. I have seen that sitting there for a year, so it really doesn't mean anything. So it's just a waiting game at this point. You're welcome. All right, so keep putting those questions in the comments. So I'm from Jamaica. I'm married to a US citizen. My daughter is an American. Do I have to involve her in the process? My husband is not her dad. I would have to understand what's going on in the case. But if your spouse is sponsoring you and she is already a citizen, you always disclose the information that's asked of you on the application. And so if they ask about your children, you do have to disclose who your children are, usually their date of birth. So in that sense, you may have to add them to the application, but it doesn't mean that they're going to go to the interview or get involved in a very deep or active way. But all information on the application, you should be disclosing that. Thanks for the love. I appreciate it. Let's say me and my wife are students in different states, therefore we don't live together. Is that a red flag? No, it's a red flag in that the officer is going to spot that immediately. They're going to spot the fact that you don't live together, and they're going to follow up on that on that issue, which, because it's a red flag when you don't live together. But it doesn't mean you can't overcome that red flag or that suspicion. The officer is trained to look out for things like this, to look out whether you're living together, whether you're living apart. And, it's going to come down to your particular circumstances. In this case, you say you're students in different states, and there may be a good reason why you can't be in the same, you can't go to the same school. You may be 3/4 of the way through your course. You may have gotten a scholarship, and so you don't want to leave the scholarship, and so you're waiting until you finish your education. I mean, there could be a number of acceptable reasons, but it's a matter of laying it out for the officers so that they understand that there's a good reason for this. And also shoring up the other evidence that you have of your marriage. I often say married couples don't live completely separate lives. It's just not reality. And so even if you're not in the same states, the officer is going to look at, well, okay, you said that you're going to school in different states. That's why you live apart. The officer is going to look at other things. Do you share bank accounts? Do you guys travel often to see each other? Are both of your names on the lease, even though you may be living apart in different states? It's supposed to be a normal that when you're married, that you act as if you're married, and marriage means that you're going to take steps to commit to each other for the long term. And so you're going to see you're going to have other evidence of your marriage. Thanks for that question. So put those questions in the comments. I am closing out, but what I do want to say is I'm going to Instagram. I'm the immigration attorney on Instagram. You can join me there, and then we can continue to have a conversation there and answer your questions. So I see here a question on YouTube. While I'm waiting for my interview for removal, can I apply for citizenship? We are married already for almost 3 years and 2.5 when I get my conditional green card. Yes, that is permissible. You would be able to apply at the same time. They do still have to approve the removal of the conditions. And what they have done in some cases is they will do the interview for the removal of conditions and then jumps. And if there are no issues there, they feel like they can approve the removal of conditions, they jump straight into the citizenship interview and exam. And then on the spot, you could get your green card and then your citizenship approved to get citizenship at the interview. So that is a possibility. Usually you can submit your citizenship application at 2 years, the 2-year and 9-month mark. All right. Okay, so I'm heading on over to Instagram where I'll continue the conversation there. So I will see you in tomorrow where we'll continue to have this conversation. I'll bring a topic, you bring your questions. Now, while the case has been reviewed, is it safe to visit my family in the USA since I'm outside of the USA? That is going to, I only advise my clients on this because you have to know what's going on in your situation to say whether it's risky or whether you have a goal. And also the risk associated with traveling into the US while you wait for your process. All right, have a great evening. I'll see you tomorrow. Thanks, everyone. Bye-bye.